position. It is noteworthy that the Court of Appeal's decision in Cape Distribution and O'Loughlin was not cited, and it is clearly of higher authority should the two decisions not be wholly reconcilable. Well, if that is an assertion that Mr. Justice J was wrong to say that there is no, as it were, freestanding claim for loss of earnings, then we respectfully say two things. Firstly, Burgess and Malyon and Plummer were the authorities relied upon by Mr. Justice J. Secondly, the Cape Distribution, with great respect, has nothing to do with it. It's entirely unclear what he thinks Cape Distribution could have contributed to that issue. But again, it's talking about the loss of her career. Again, this looks like the alternative award. In paragraph 55, in the fourth line down, she had a reasonable expectation of pecuniary advantage, namely the money she would have earned at work from the continuation of Neil's life. He would have continued to look after their home and their children. And then he deals in paragraph 56 with the point I've already covered, which, that being the case, is it a dependency resulting from the relationship of Neil and the claimant as husband and wife, or was it simply or purely incidental to that relationship? And he distinguishes the Burgess and Cox on their facts. I don't think I need to say anything more about that. I've made submissions about it. But it is, with respect, a little surprising that given that he says it has said in paragraph 59, he accepts that it's not appropriate to value the claimant's dependency on the basis of the claimant's loss of earnings, that we then proceed to evaluation which is commercial care, which would be, leave aside my ground 3, is the approach to be adopted in relation to a loss suffered by children who are eligible dependents. If the family's loss is the, as he put it, the family's finances decreasing by the measure of the claimant's lost earnings in paragraph 52, then that's a totally different measure. And of course, it brings, as my Lord Justice Stuart-Smith said, it brings in this Harrison Empress Motors and Coward and Comix calculation. So one looks at what the net financial loss is. So we say that the reasoning does not add up. This isn't an attack on the judge's findings of fact, pure findings of fact. I think, therefore, I have covered ground 1. In summary, the judge has allowed the claimant effectively to sidestep the restriction on the numbers of, on the categories of people who may claim as dependents under the Fatal Accidents Act for a loss of services which, in any event, they have not lost, and which has continued, was never provided gratuitously, has continued at the expense of the County Council, who continue to have parental responsibility. Now, ground 2, which is just to remind the court, is set out at Core Bundle 25 in my skeleton argument. My learned friend, I hope I can deal with this fairly shortly, objects to this as being something that wasn't raised below, and he relies.
So did Lord Justice Coulson.
I'm not. Well, I wasn't aware of that. Perhaps I could just look at. Well, he said ground.
Or was it the judge?
Forgive me, my lady. It's the trial.
I'm so sorry.
Yes,
it's the trial
no, that's
judge.
right.
It was the trial judge.
That was what I was going to. And in fact, it's just to see what the ground is. In the alternative, the claimant's loss in replacing the deceased child care services can only be given a pecuniary value which takes account of the fostering allowance and other benefits she receives. And my learned friends say, and this is at page 111 of the core bundle in their skeleton, that this is a new point, and the trial judge recognised this when refusing permission on what was then put forward as a ground 5 of some grounds. Paragraph 71, Learned Friends skeleton, quotes the formulation of what was then ground 5, is slightly differently worded.
Sorry, can you have the page on that?
111 of the core bundle, lady. And what that ground that was put before the learned judge was the court failed to take into account the value of the fostering allowance and other benefits payable to the claimant as mitigating the effect of any loss of services dependency suffered by her. And the learned judge, in his written reasons for refusing, stated grounds 3, 5, 7, and 8 were not raised during the course of the trial. Ground 5 would have required detailed evidence challenging analysis and argument. Now, my lords, there may have been a misunderstanding, and it's entirely my fault for the poor drafting of that ground at the time, but this was never intended to be a failure to mitigate argument, which indeed would have required evidence challenge and so on. This was simply another way of putting the point, which I've already laboured under ground 1, that this wasn't gratuitous. These were not gratuitous services, and they've been carried on by the claimant in consideration of the allowance which she now gets. And it really is an adjunct to ground 1. And the point was repeatedly made. Well, everyone said it wasn't raised at the trial. The point was repeatedly made during the trial that the claimant was receiving this fostering allowance, and indeed the judge sets out the earnings she received in paragraph 27 of his judgment. And my closing submissions, if I can just take the court to supplementary bundle paragraph, page 74, closing submissions to the judge. Paragraph 20 complained that it was simply relabelling the claim as if it amounts to a loss of services provided to the claimant herself. And the authorities on which reliance was placed concerned with a very different situation, namely the provision of gratuitous services. And the reason why those authorities are concerned with gratuitous activities is obvious. If the activities had been paid for at full commercial value by the person who was enjoying them, by definition there would have been no loss, because the value of the services lost would be offset by the saving in the payment. And in paragraph at page 78, 79, I think, in fact. No, I'm sorry, it's back, sorry.
Mr. Kent, I'm sorry to interrupt, but is this fair? If you're right on ground 1, you don't need ground 2.
No, that's true. Yeah.
If you're wrong on ground 1, ground 2 doesn't help you.
Well, it has this feature, because if I'm completely wrong on ground 1, yes. If, on the other hand, the judge has got to the right conclusion by the wrong route, then account should be taken of the payment for the care, because if she is the replacement carer, then you would expect that amount to be taken into account. In other words, if this can be presented as if it were a claim by the children. If I can give an example, imagine very conventionally you have a services dependency based on DIY or gardening services. Imagine a case where a couple live in rented accommodation. The landlord is responsible for maintaining the garden, but he pays the husband to do it. Husband is then killed. The widow suffers no loss because she can demand, in respect of gardening, she can demand that the landlord does the job, and she may be paid to do it herself. It's that sort of situation where you have not a gratuitous activity, but a paid activity, which is simply continued and distinguishes it from the cases that the court was relying upon, which are all cases of gratuitous care. But what I wanted to just to draw attention to was in paragraph 20, which is page. No, I think I've dealt with that. Sorry, it's paragraph 15 I meant on page 74. Paragraph 15, there can be no doubt that were the children eligible to claim as dependents themselves and had the funding for the care previously supplied by NW not continued, there would have been no question of their dependency claim being presented as if it were the claimant's own loss. And in paragraph 16, after citing Mr. Justice J, the end, it's submitted, neither is true in this case, nor is the claimant now supplying those services for no financial reward so as to make a loss of earnings from alternative employment an available proxy for the loss. So I'm making the point, it's not a failure to mitigate point, it's a way of analysing, seeking to analyse in truth what is the nature of the claim, which can properly be put forward in this case. But I will move on rapidly to ground 3, which is the commercial cost. I've already identified the way in which the judge saw this as a case of services dependency, simply because, and I say simply, that's not to devalue it, because Mrs. Witham would have been able to go out to resume her nursing career. That was the plan, and accepted to be such. And therefore, as the judge said, the household finances are diminished. That being the case, that being how one gets through the gateway of what is this dependency claim by the claimant herself rather than the children, it is slightly odd, we say, then to move on to commercial care rates. If I can just remind the court what was said in the claim, because one needs to look at the schedule of loss, which starts at in the supplementary bundle at page 1, but the key Fatal Accident Act claim is at page 11. There were the page 11 is headed dependency on the deceased's childcare and domestic services, focusing on the childcare. Then the first primary approach on page 12, a commercial valuation of care, and it was put forward based upon the care expert's report, and this was entirely accepted by the judge, at $53,031 per annum for the care element, the childcare element, and various extra bits which came to another £14,721 per annum. That's the middle paragraph, page 12. All of which was valued on, was calculated on what's called a commercial rate, as is made clear by the rubric. The alternative, the loss of earnings claim, over the page, projected the claimant's resumed career, and it was assumed that she would go back to nursing at £38,765 per annum gross, but then over the period with which we were then concerned, the full period of the fostering up to 2029, this would have risen to £44,792, and a mid-point, tax and after tax, just below the middle of the page, £33,000, just under £34,000. So
you do accept, don't you, that if a dependency claim is admissible in principle, so if you lose on your other matters, it is better to do it by reference to value of services rather than loss of earnings?
Not in this case. I mean,
why not?
Because on the facts of this case, the commercial costs can never be incurred.
Why not?
Because Mrs. Witham, as part of
doesn't that cut straight across the principle that you award damages to represent the loss, and how the claimant spends it is entirely a matter for her?
No, well, I'm going to come to the authorities on that, but leave that aside. In this case, she's required to be the carer under the Foster Plus agreement. She couldn't subcontract her care responsibilities. So it had to be, and this was common ground. It had to be, therefore, care that she would continue to do herself. Now, if she was therefore being compensated as a gratuitous carer, as one often sees in these cases, then in this case, leaving aside all my other points about the ability to claim loss of earnings simpliciter, one would have thought that
Well, isn't the logical conclusion from that remark, from that position, that you end up giving cost of care subject to deduction for income tax and so on? You give net cost of care.
Well, that's another. Yes, I mean that's part of my submission under ground 3. That if you're going to go down the what would it cost, how do you value it, so much per hour, then you take off the 25% conventionally.
Well, I may have misunderstood the position. I didn't think that you were contending that loss of earnings and pension was an appropriate way of valuing this dependency if a dependency is established.
Ground 3 is, I accept, an alternative to ground 1, not in respect of all of it, because there were some other items of claim that weren't childcare. We do say that this isn't, that the bulk of it, the childcare element, is not, for the reasons I've given, is not available. It's not a services dependency suffered by him. But if we're wrong about that, then of course the court has to evaluate that care. And what I'm pointing out at the moment is that the judge, having effectively, and of course we don't, until we see the judgment, we don't know which route he's going to go down, having effectively said this is an impact on the family finances case, it is curious that he then goes down the commercial care route.
But I don't understand that.
It made me curious, but he was entitled.
I don't understand that, because what he actually says is there's a loss of dependency here, and one of the knock-on effects undoubtedly is loss of earnings.
Yes.
That's one question. Is there a loss of dependency? He then, when he comes to value it, says, well, I've got two alternative ways of doing it. Her loss of, Mrs. Witham's loss of earnings, or the value of the services. And I would actually just like a straight answer on this. I don't mean that your answers have been anything other than straight, but I would like to understand your position. Are you saying that if the dependency is established, it should be valued by reference to cost of care or by reference to loss of earnings?
My lord, in this case, we say the most you could do is loss of earnings, and for this reason, because the services dependency cannot be that enjoyed by the children, and can only be that enjoyed by Mrs. Witham, and because the judge has identified that services dependency as being a service given to her to enable her to go back to work, that is the only route available.
Well, doesn't that lead to the conclusion that you value by reference to the cost of services? I'm obviously being very straight.
Yeah, yes, but the cost of the services. The problem is that because of this unusual situation, she cannot subcontract. She can't go out to work, saying I'm leaving the children in the care of Mrs. X, whom I've got to pay so much to do it. She wouldn't be allowed to do it. And so in this case, all that has been identified as the services dependency, which has been lost by the judge as a matter of fact, is the inability of her.
But if her earnings had happily been twice as much as they were, so that this basis produced an absolutely magnificent award of damages, would you still be making this submission?
Well, I couldn't. If I've lost ground 1, I couldn't. But if I've, but because that would be, notwithstanding my submissions about, based on Mr. Justice J, that there's no loss of earnings claim, simpliciter, as he put it. This court would have rejected that, and therefore you'd be saying there is a loss, and the defendant's just got to put up with it. If it turns into a multi-million-pound loss.
You've got to compensate properly. The question then is, if you're dealing with a dependency which is a services dependency,
yes,
are you submitting that you should not value it by reference to the cost or value of services?
I am submitting that two things. First of all, if you're going to do it by reference to the value of the services, that the authorities suggest that you don't award the commercial rate.
That's not an answer to my question. My question is, are you going down the loss of services route or the cost of services route, whether you net it off or otherwise, or are you saying, which I think you said a moment ago, in this case the most you can do is loss of earnings?
Well, I think I am saying that. Your Lordship's question is predicated on me losing ground 1,
yes,
so we're in that.
It is predicated on you losing ground
yes.
1. I want to know what the opposition is if you've lost ground 1. Which is not to give you any indication at all.
No. But the answer must be that each case must turn on its own facts. The judge has made his findings of fact. He's identified the services dependency. He's identified it as the value to Mrs. Witham of her husband being present in the house and her leaving her free to resume her career. That is why he is providing any services to her. Let us not forget, he's not otherwise providing services to her. He's providing services to the children. And that's why, on the facts of this particular case, on the judge's conclusions, this appears, if anything, leaving aside ground one, to be, as he said, a diminution in the family finances, which can be calculated. And yet what he's done is he's gone down this commercial care route, which we say is wholly artificial because it will never be incurred.
Well, you still haven't answered the question.
Yeah.
Are you saying that the judge was wrong to do this, or are you saying it was curious and you don't think it's particularly logical, but you can't actually set it aside because there's a wide discretion given to the judge?
Yeah, I say he was wrong because on the facts that he's identified, he has been very specific about what this services dependency is. In other words, it's not a childcare dependency. It may be described in that way in the schedule of loss. But for example, if a couple were running a small holding and one of them needed to be present to milk the goats, that might then enable the other to go out to work, and that may be then impossible following the death of one. It's that sort of dependency which has been identified. And once you look at it through that lens, which the judge has done, then to move to valuing the childcare dependency is to move sideways to deal with something completely different. So I do say he was wrong to approach it in that way on his findings.
I hadn't understand that to be a ground of appeal, I have to say. There it is.
Well,
did you argue below that was the proper, that if you were wrong on your first point, that would be the proper basis to determine?
No, we took our stand on the basis that this was there was no identified dependency within the authorities that could be recovered. But Your Lordship, I've already pointed out there's no respondent's notice resurrecting, as it were, as an alternative, a loss of earnings claim. So the questions that are being put to me are, I would submit, of forensic purpose rather than anything else.
No, they're not. Speaking entirely for myself, the route that I understand you to want us to go is, first of all, ground one. You've said ground five for a moment. Ground one. And then if you lose on ground one, I was trying to find out what you say was the proper basis for assessing the dependency that would arise if you've lost ground one. That's all I was trying to do. It's not meant to be forensic. It's meant to be real.
Well, then I thought I'd answer that by saying that on the finding that the judge makes, if that is a sustainable finding, then the identification of the dependency, then it is not a commercial childcare method of evaluation. In other words, there will be many dependency claims under the Fatal Accidents Act which are fact specific. Some to do with personal care provided, some to do with the management of a business like Cape and O'Loughlin. You have to focus on what it is that is the loss, why it is that the dependents say there's a loss at all. Why they get through that gateway of demonstrating a loss which needs to be compensated. And so that's why we say that this is simply following the judge's own logic in that respect. And to award something which amounts to, because the commercial care was, with these add-ons, probably double the gratuitous care rate that Lynn Hannon had assessed. It employers' national insurance contribution, employers' liability cover, nanny tax, nanny expenses, some placement fees of $3,500 every year for recruitment, 6 weeks to cover sick pay and holiday pay for them. These are all entirely notional. They can never be incurred. And one of the points I'm going to make is that the authorities show it is a fact-specific exercise. can I turn to the authorities?
Are you still on ground 2? Because you seem
No,
to
I'm sorry,
like-
this is ground 3. I've moved rapidly on. I should have. The judge at paragraph 64 of his judgment said that commercial rates were appropriate, and he referred to daily. He referred to Mr. Justice Bean, as he then was in now Ministry of Justice, and he also referred to daily and general steamship. He rejected the argument based upon Housecroft and Burnett. Can I just quickly take the court to those authorities? First of all, going as it were backwards, Mr. Justice Bean in the Nauer case is at in the bundle. It's tab 20. Thank you. Tab 20. And this was a fatal accident claim. Went later to the Supreme Court by.
Could you just give me the tab number once more?
Tab 20. Lord.
Thank you.
And the bit that the learned judge relied upon is paragraph 26 of the judgment of Mr. Justice Bean, referring to daily and general steam navigation. Starts with respect to misconceived on basic principles of the law of tort if a claimant, and he refers to the Rolls-Royce being written off and so on. And he says the same principle applies to claims for loss of services under the Fatal Accidents Act. And to claims of future loss, they're not past loss brought by a living claimant for her own personal injuries, daily and general steam navigation. So he's relying upon the authorities partly in relation to personal injury claims and partly in relation to fatal accidents claims. But can I just point out that the argument for the defendant was an all or nothing one, because paragraph 25, Mr. Poole argued vigorously there should be no award for either past or future services dependency. 5 years have passed since Mrs. Nauer's death. He points out yet Mr. Nauer has not engaged a paid cook, cleaner, gardener or a decorator, still less a resident housekeeper. So that was the issue. It was an all or nothing argument. And the conclusion was that there should be an award. And in addition to daily and general steam, there's reference to Hay and Hughes, where Lord Edmund Davies says, this is paragraph 27, the fact that a widower decided to manage himself after the death of his wife would not entitle him to sue for and recover damages for the pecuniary loss he had sustained. So this isn't directly addressing the question of how you calculate that loss. It is rejecting the argument that you have to have employed paid help or demonstrate that you're going to do so. And if we go back to the line of authority, daily itself is, because what I submit the authorities show is that what the court is concerned with is a reasonable award, which will be fact dependent. Daily is at tab 10, was a personal injury claim, and the plaintiff couldn't perform household duties in the way she could. But it's important to see that at page 126, what the judge decided in that case, Mr. Justice Brandon.
I'm sorry, which tab?
It's tab 10, lady, and it's page 126 of the report. Mr. Justice Brandon is quoted just below letter C, where the person concerned is a housewife who is disabled wholly or partly from doing housekeeping in her own home. She does not suffer. He's setting out the argument. Suffer an actual loss of earnings unless a substitute is employed, and may not suffer any pecuniary loss at all. Nevertheless, she is just as much disabled from doing her unpaid job as an employed person. And I think she is in principle entitled to compensated separately for her loss. And then Lord Justice Bridge continues basically that is the proposition which Mr. Bennett, the defendant's, challenges. So it is again an all or nothing argument. She hasn't incurred any expense, therefore there should be no loss. no claim, and the claim was put at fairly modest 10 hours a week at 90 pence per hour. And then at 127, which is sidelined, Lord Justice Bridge says, just below B, it's been energetically argued by Mr. Bennett for the defendants that before a future loss of capacity to undertake housekeeping duties can properly be assessed, and so on, the plaintiff has to satisfy the court that she has a firm intention in any event that such a person shall be employed. For my part, I'm quite unable to see why that should be so. And dropping down a bit, says it was entirely reasonable and entirely in accordance with principle in assessing damages to say that the estimated cost of employing labour for that time for an appropriate number of years, having regard to the plaintiff's expectation of life, was the proper measure of her damages under this heading. Quite immaterial whether what she chooses to do with it. At G, he notes that it's illogical, but that wouldn't be true in a personal injury case in the period before trial. That's catered for by an increment on the general damages. So that's Lord Justice Bridge. And of course, taken in isolation, though noting that it was really dealing with this all or nothing argument, there is support, obviously, as the judge thought, for the proposition that it's always going to be the commercial cost which is recoverable, whether incurred or not. Lord Justice Ormerod, right at the end of the report, has some points to make. He deals, first of all, with the pre-trial loss, and notes just above letter C, not necessarily reliable to have regard to market values of housekeepers. It introduces a wildly artificial concept if one resorts to that and talks about compensating the husband, in this case at a rate of a daily woman, 7 hours a week, does not represent reality at all. And then the next paragraph, so far as the future loss is concerned, I entirely agree with what Lord Justice Bridge has said. The judge's method of assessing that part of general damage represented by the future cost, at least in theory, of supplementing the plaintiff's capacity to do her housework, seems to be perfectly reasonable. Has to be quantified in some way, but one has to be able to get the order of magnitude of the sum to be awarded. And he says the judge adopted a reasonable approach. And so it's not, in fact, the case that the Court of Appeal there were being particularly prescriptive about the approach to be adopted. And then in contrast, we have Housecroft and Burnett, the next tab. Lord Justice O'Connor considering a claim, again in a personal injury case. And at page 13 of this report, he says, well, the needs of the injured plaintiff are and will be supplied by a relative or friend out of love and affection, freely and without regard to monetary reward. How should the court assess the proper and reasonable cost? There are two extreme solutions. One, assess the full commercial rate for supplying the needs, or two, assess the cost at nil. Let me say at once, the defendant's present case is not contended for the second solution. The reason why a nil assessment is made, where the plaintiff is to be looked after under the National Health Service.
Where are you?
Oh, bottom of page 13, last paragraph.
Yep.
And then he refers to the National Health and Lord Scarman in Limpo Chu, that there's no claim for medical expenses where you're to be cared for free in the National Health Service. And there's some similarity there, because this is a case where the calculation is based upon the cost of costs which can never be and will never be incurred. And what Lord Justice O'Connor says at the middle of the next page, after referring to various authorities, once it is understood, so an element in the award is to provide for the reasonable and proper care of the plaintiff, and that a capital sum is to be available for that purpose, the court should look at it as a whole and consider whether on the facts of the case it is sufficient to enable the plaintiff, among other things, to make reasonable recompense to the relative. So in cases where the relative has given up gainful employment to look after the plaintiff, I would regard it as natural. The plaintiff would not wish the relative to be a loser. The loser, the court would award sufficient to enable the plaintiff to achieve that result. The ceiling would be the commercial rate. Then in the next paragraph, the court is recognising that part of the reasonable and proper cost of providing for the plaintiff's needs is to enable her to make a present or a series of presents to her mother. Neither of the extreme solutions is right. The assessment would be somewhere in between, depending on the facts of the case. And following Housecroft, there was this convention in personal injury cases that for gratuitous care there was an hourly rate then discounted by the saving on by 25% usually because the carer doesn't incur tax or national insurance liabilities. Then paragraph tab 12 is a fatal accidents case, so more to the point. Spittle and
I'm just
I'm sorry.
flagging up time.
Yes.
Right?
Well, I think this is going to be. I can move fairly rapidly from here. Spittle and Bunny, tab 12, Fatal Accidents Act claim. The mother was killed and leaving a child. Can I just take the court first of all to page 857, where Lord Edmund Davies in Hay and Hughes, Mr. Justice Bean in Nower referred to Hay and Hughes, is quoted saying, in fact, he was quoting from the speech of Lord Duparc, top of 857, in the end what has to be decided is a question of fact and therefore a question proper for a jury. Circumstances so infinitely various that however carefully general rules are framed, they must be construed with some liberality and not too rigidly applied. And so on. And then Lord Edmund Davies goes on in the middle of that quote, just between C and D, the loss suffered by the dependents must be assessed as best they can in the light of the particular facts. But having done his arithmetic, there comes a stage when the judge has to stand back and look at the result. When he should bear in mind the wise words of Lord Justice Wilmer, essentially a jury in question, and so on. And so Lord Justice Croom Johnson, going over the page, says this at B, as to how they should value Kate's mother's services, they were not to use as a measure the evidence of the cost of fostering services. They should be told they were to use what other evidence the cost of a nanny is, as they thought best. If they thought that that did not properly reflect the true value of the services of Kate's mother, they should stand back and use their common sense. So it's a rather more nuanced approach that is adopted in that case. And the reason I said I would come back to Lowe and Guy's is really because there's an extensive quote from Lord Bridge in Hunt and Severs.
Well, would you like to give it to us? Because we're coming up to 3 o'clock,
Yes.
and I'm very concerned that Mr. Snowden hasn't got to his feet.
I will get. Can I identify the reference? Paragraph 15 of Lord Justice Ricks in Lowe and Guy's, which is tab 17. Quoting Lord Bridge in Hunt and Severs says, it's the proper and reasonable costs of supplying his needs. Paragraph 16, Lord Justice Ricks notes that the old rule that, or the suggestion that to make such a claim, the carer ought to enter into a contract with the claimant, was should certainly not be followed, and cites McGregor on damages, where it was said that it would be liable to lead to the more expensive use of professional carers. That's at the middle of, that's page 1375, was the middle of paragraph 16. And so there is, I think that's all I need from that. So there is a citation from Lord Bridge himself, who of course we go back to daily with Lord Justice Bridge as he then was, saying it's really a question of what is reasonable, and Lord Edmund Davies that it's fact specific, and where the facts are as they are in this case, that there will be these extras will not be incurred. To award an amount by way of a lump sum, which is to provide a net present value, a fund as it were, to defray expenses as they are incurred, it is, with respect, not a reasonable amount, not a reasonable sum if it includes things like holiday pay for carers who will never be employed, or employers' liability insurance, those sort of things.
How do you cover the period when Mr. Witham would have been providing cover 52 weeks a year, but if you were buying it, you would have to go out and get respite care?
Well, my lord, by saying that you cannot buy it because of the fostering arrangement.
If the court is decides to formulate a lump sum
Yes.
by reference to cost of care, which is a big if.
Yes.
If it does, how then should the court deal with the 6 weeks or so when the paid carer who is brought in for the notional paid carer is on holiday and replacement care has to be obtained?
Well, if you have a case where there is a real prospect of paid care being employed, then that's one of the factors.
No, you know, I'm asking you about where you're dealing with your notional case.
Yes.
If in your what you are saying is notional.
Yes.
So if the court decides that despite the fact that Mrs. Witham will be providing the care, an appropriate means of valuing the dependency is by reference to the commercial cost of providing care. How do you deal with the 6 weeks when the normal carer is on holiday?
Well, you don't award it because there are, as in Daily itself, someone just came up with an hourly rate and they said, well, it's 10 hours a week, therefore it's £9 a week. That was the care. That was the valuation in that case. What I say we don't find in these cases where it is clear it won't be incurred is this wholly artificial spreadsheet of additional costs, as if you are investing in a business and you want to know what it's going to cost you. It simply is so far removed from reality that it's not no sense.
Do you value that for those 6 weeks? Do you value the dependency at nil?
Well, the 6 weeks don't exist; they're entirely notional. There are only 52 weeks in the year, and so this care claim has been put forward on the basis of 58 weeks. And the reason you have 6 weeks, if you have a commercial care package, is because you cannot employ, because of the risk that there will be sickness, and because the professional carers have to have holidays, and that's very conventional in a big personal injury case where there's no doubt that the very badly injured claimant needs to have this care, and there can't be any risk of him or her being left uncared for because the carers are sick. So that is then factored into the award. It's part of the reasonable cost. We are so far removed from that we say that something has gone wrong in this case, which awards it in the way.
So, Mr. Kent, cutting through it, and very shortly indeed, will you identify those sums or factors which played a part in this award which you say should not have been there?
Well, it's the the paid carer rate, £11.15 an hour was taken by Miss Hannon for gratuitous care, £15.90 I think it was for paid care, rising to £18.91 for some aspects of it. The employer's national insurance contributions, the employer. Well, perhaps we should have put the report in the bundle, but there is a schedule of.
Yeah. Please.
I do have a copy.
Not necessarily now,
No,
but
not
we
now.
have copies.
It's not. I don't mean the report. Ms. Hannon provided a schedule, which looks like that. It's just a few pages, where it's all set out, and which was adopted. But I think I've got copies.
Mr. Kent can be handed in later or sent.
Yes, I'll find them. Those I think are submissions.
Sorry, may I just,
Yes.
sorry to clarify ground 3 exactly now of your appeal, your amended grounds of appeal on page 11,
Yes.
the core bundle, just so I've got it absolutely clear.
Yes.
Are you saying, firstly, it's contrary to a principle to assess the value of the dependency by reference to the cost of replacing the same, and it ought to be by reference to the lost income of the claimant, point 1. And secondly, if and insofar as you are judging it by the commercial cost, then you should take into account these factors which you just identified, which
Yes.
should have reduced the figure. But they're those two quite distinct points.
Yes. Well, Lord, our principal argument was that you should do this as you would do a gratuitous care award, and therefore take a reasonable hourly rate and then discount it by 25%, and you wouldn't have these add-ons, as I've called them. And so there is a cheaper way of doing it. That's taking the cost of care. The alternative, as we've discussed earlier, is that.
I'm sorry, but I'm trying to get it straight. it's not just a question of an alternative. Is your point one, the judge did the wrong thing and the right thing was to assess by reference to the salary that was lost by the claimant? And therefore, if we were to uphold you on that ground, that would be the level of compensation which should be awarded.
No, my lord, our case has been in this court that these should have been assessed as gratuitous care rates. I haven't given the figures, but it would be at a lower hourly rate and it would take off 25%, wouldn't have the add-ons. And so the approach would then, it would need adjusting. Originally, we said that the matter should be remitted. It looks as though it may have to be in any event, well, depending on ground 5. But the judge's findings, obviously accepting Lynn Hannon's approach, that her schedule provides.
So we can forget about entirely the salary that she has lost. You're not saying it should have been by reference to that.
Well, my lord, forget about it in this sense that my learned friend hasn't resurrected that argument. It's not for us, as it were, to do so.
I mean, the judge decided it on the basis of commercial rates.
Yes.
You could be saying that basic approach is wrong. He should have decided it on the basis of lost salary.
Yes.
I thought you were saying that, in fact. But if I've got that wrong, then the question is, you are then saying we agree that that rates, depending upon the cost of providing the alternative care, is the right way of doing it, but it should have been done with these discounts that you're referring to.
Yes. Well, my lord, all we were seeking to say was that if this was done in a conventional gratuitous care way, then the court would say, has it worked? Has the carer given up work? That may provide a proxy for, as Mr. Justice Jay said, for the loss. Or if that's not the case, or it's inappropriate to use that, what is a reasonable hourly rate for her contribution? And we have our ground 2, which of course says that she is being paid for it. So it's not quite as simple as that. So our primary argument is simply if you take the elements that the judge took on ground 3, they should be done the number of hours per year. It should be done on a gratuitous basis with a 25% discount in the normal way. That was always our intended argument. And I think that's reflected in the skeleton argument. But the point about the loss of earnings is really just derived from my forensic points about the way in which the judge identified the nature of the services dependencies.
Thank you, Mr. Kent. Mr. Snowden.
My lady, I may be being optimistic, but I do hope to be much briefer than Mr. Kent on this occasion, unlike our last series of exchanges. My lady and my lords, our arguments really could be summed up in this way. The judge got it right, he got it right, he got it right. He did what was necessary. The awards that he made and his approach were entirely within the range of discretion that he had, because he is not fettered by any particular approach to calculating the dependency.
Because these are fact-specific cases.
These are fact-specific cases, precisely. We say this case almost entirely turns on its facts. And what Mr. Kent endeavours to elevate to propositions of law and to say, effectively, to invite your lordships to constrain future fatal accident trial judges to a particular narrow path or a particular track are unattractive, because the judge has to be able to recognise that each case is different. Each case turns on its own facts. In some cases, there may indeed have to be the... Let me start that again. Mr. Kent, as part of his submissions, decried this approach as saying this would lead to, in particular in relation to the element of was this an employed loss or was this one arising from the relationship, this would lead to an invidious inquiry in every case. But, my lady and my lords, effectively, every fatal accident claim must begin with the inquiry of, is there a relationship? Is there the clause within the Act? Is there an expectation of pecuniary benefit from that relationship within the Act? And if so, then the gates are opened for the judge to do what he or she identifies as appropriate to properly reflect on the basis of a jury award. And I'm not simply saying, laissez-faire, any judge could do anything they like and not be wrong. But it's not appropriate to suggest that this judge has erred in principle when one can see, and we'll take you back through this when we come to effectively what I think is Mr. Kent's ground one, and his suggestion that the judge looked as if he was going down an earnings route and then he looked as if he was going down a care route. What this judge has done is identified in his mind and found what the loss of pecuniary advantage was, the aspects in which Mrs. Witham depended upon her husband Neil. And that was to have allowed her to go out to work, to earn and to have a career.
Sorry, just hold on a
So
minute.
sorry.
No, just the aspects on which Mrs. Witham depended on her husband Neil.
There's her to go out to work. Oh, sorry, forgive me. It's for him to shoulder more than the 50% share of the housework and the care and provision for the foster children, so that she could be released to pursue a career. But what the judge has then done is reined himself back in and said, perhaps it's not articulated clearly in the judgment, but has reined himself back in and said, now, what should I, as a jury, do? Should I give her the full loss of earnings? Should I measure it by reference to commercial valuation of the time that her husband Neil would have spent? If I do that, bearing in mind, amongst other factors, that these are two autistic children with greater than normal needs for care and attention, do I make a discount or don't I? And the judge navigating his way through this case in that way, we say, is beyond reproach, because the logic of his approach is apparent. But let me take a step back and let me come to ground one. My lady, what I will do again is repeat our skeleton argument to you. I know, my lady, my lords, you've read that.
Just give us any paragraph numbers you particularly want us to read again.
Certainly. Well, in a sense, what I would invite you to do is to read the skeleton again in relation to ground one.
Yep.
I'm afraid I would. Because we've set out through ground one covers, I think, paragraphs 34 to 69. And we set out the logical steps there that the judge followed. He identified whether there was a reasonable expectation of pecuniary advantage from the continuance of the life of the deceased. That's a reference from O'Loughlin and Cape, and we will look very. I will take my lady, my lords, to O'Loughlin and Cape as Mr. Kent didn't. The learned judge was then right to characterise the loss as being Mrs. Witham's. And again, simply to expand on that a little, the fact that an activity benefits the foster children doesn't mean that it can't at the same time benefit Mrs. Witham. Perhaps too many negatives in that sentence. Put another way, Mrs. Witham can properly be dependent upon the deceased for him undertaking activities with or doing things for the foster children. For instance, taking them to school. That benefits the foster children, but it benefits her because she doesn't have to be present and driving a car 50% of the time or all the time between 8:30 and 9 in the morning. She can go to work. She can start early. She can do bank shifts. So the sacrifice and the division of their time benefits her because it frees her from, call it a burden, it would be wrong, but domestic and child responsibilities, which otherwise wouldn't want to expect to be equally shared. when we use the expression that those services are gratuitously given, they're gratuitously given not in the sense that Neil Witham's not paid by the local authority, or that there's no funding from the local authority of the childcare. They are gratuitously given to Mrs. Witham. He voluntarily assumes the responsibility to do those things which otherwise would fall jointly on both of their shoulders. So she is, we say, the beneficiary of the gratuitous gift of his time and his activity.
Is it one way of expressing it that she is the beneficiary of a loss of services which had the knock-on effect of enabling her to earn?
Yes, that's how the judge considered it. That's the logical way of seeing what Mr. Kent tried to characterise as uncertainty or ambiguity or confusion in the judge's mind. The judge was, we say, pretty clear, forgive me for the colloquialism, that that's exactly what was going on. He was doing more than his share at home so that she could be free to go to work. And in that sense, put that way, as I do it, I hope succinctly now, and as I hope, in effect, eliding the judge's approach, there's nothing there which falls foul of Fatal Accidents Act. There's nothing there which falls foul of any of the authorities on how a judge needs to approach their task of assessing whether there is a loss, whether there is a dependency, or how that dependency could be calculated. So, since we come back to where I began, the judge took a perfectly acceptable approach to ascertaining whether there was a dependency, how it might be measured, and what he would choose to award. And it is, in that sense, beyond criticism, largely because it is based on findings of fact of this unique case.
Reversing the question that we asked Mr. Kent, would it have been wrong in principle had he decided to value the loss of services by reference to what would, I think, have been her net loss of earnings?
No, it wouldn't, because we did invite him to consider that approach. It wouldn't be wrong in principle at all.
But it would have been net, wouldn't it? Because of Orty and Gourley and things like that.
Net of?
If you were doing it by reference to her loss of income.
Yes.
The consequential, the knock-on loss of income. Wouldn't you do it by reference to the net loss of income? Rather than her pre-tax figure?
Oh, my lord, yes. My lord, yes. Sorry, forgive me, I wasn't sure whether you meant net of that or net of what Mr. Kent has characterised as a group of benefits and allowances and support payments and we say goodness knows what, because it wasn't satisfactorily explored at trial. Might have been payable by the local authority in respect of Mr. and Mrs. Witham having these foster children with them. There was no particularly detailed exploration of whether any of it reflected salary, whether any of it respected allowances, whether any of it was specific for the children's needs, whether any of it reflected expenses. That simply didn't take place at trial. So forgive me, my lord, for my misunderstanding of the question.
So the position is this, because it really goes back, for example, to the case of Wood and Lords Beldam and Staunton, where they are saying you don't get more fact-specific cases than the FAA cases. I mean, that's what you do. It's a step-by-step process, which you say the judge went through. And when it came to how do you value the services, he could have gone down one route or the other.
He could have gone down one route or the other, and he presumably, to our detriment, looked at the figure that arose from loss of earnings and decided...
Could you speak up?
Forgive me. Presumably
my hearing is not very good.
I'm so sorry, I'm speaking more softly than I should. Presumably he looked at the figure that we had extrapolated for loss of earnings and stood back and doing what judges are encouraged to do, said, that looks a little steep in the circumstances, I will adopt the alternative calculation. We can't criticise him for that. We're delighted, in a sense, to hear Mr. Kent's response to the prodding from my lord and others, that if he loses on ground one, then isn't loss of earnings perhaps a better measure? I'd be delighted to say that it was, but what I can't do is say the judge was wrong in the measure that he took. Those were both alternative bases open to him. May I try to make that breadth of those propositions good by taking you to Cape and O'Loughlin, if I may, which is at, excuse me, sorry, tab 16 of the authorities bundle. This was a decision of this court, of the Court of Appeal. It was an asbestos claim. It was a fatal accident claim. And the deceased was, again, what conventionally we call now a wealth creator. He was a successful businessman. And the significant parts of the judgment I take you to, if I may, are on, what's the best way to navigate? This is a printout from the personal injury and quantum law reports, but there are individual page numbers at the bottom right-hand corner. May I take the court to page 7?
So there we have the statement, what might even be called the classic statement, the reasonable expectation of pecuniary advantage from the continuance of the life of the deceased.
Yes.
Yeah.
Yes. Which we say the judge correctly received, understood, and applied in our case. It's Mr. Burton's submission, forgive me, I've perhaps taken you to the wrong section, but Mr. Burton QC, on behalf of Queen's Counsel, on behalf of the claimant, submits that is a question which doesn't predicate any particular approach, but requires a fair and reasonable assessment to be made, which will be dependent on the facts of every given case. And this is a page, this is in the judgment of Lord Justice Latham. And if I may take my lady and my lords to paragraph 11, where Lord Justice Latham refers back to the wording of section 3.1 of the Fatal Accidents Act, identifies this provision and replicates, though not in precisely the same words, the basis on which damages have been assessed since the passing of the Fatal Accidents Act 1846. The task of the court in answering this question was originally the province of the jury. Neither successive statutes, nor, in my judgment, any decisions of the courts, lay down any prescriptive method by which such damage is to be. And we pause here because Mr. Kent dwelt on the calculated, but he says identified, or apart from the principle that it requires some damage capable of being quantified in money terms must be established. So what Lord Justice Latham is telling us is that both the identification of the damage, which then turns into, as a jury question, pounds and pence, and the calculation, the approach to how to arrive at those pounds and pence, are not trammelled by any prescriptive method. And in that sense, pausing for a moment, even, we don't need to submit so in this case, but even the conventional distinction drawn for the purposes of calculation of dependency between financial loss on earnings and services is not a distinction which is written in stone, and it's not a distinction which necessarily is produced by authority, produced from authority, forgive me. It is entirely possible for the judge, a judge in a case such as ours, the very case before you, to have identified that there is something of the nature of dependency on someone's services, if we call them that, their domestic activity, which has a knock-on effect in relation to somebody's earnings, which can be calculated by a judge doing the best he can to be fair in the circumstances, choosing his way between an earnings-based calculation or a cost of care-based calculation. So we say that's the considerable significance of Lord Justice Latham at Lord Justice Latham's statement at paragraph 11. May I take my lady and my lords over to the next page, page 8, to paragraph 14 of the judgment. Still Lord Justice Latham. And again, a broad proposition. It follows, it seems to me, he says, that the court's task in any case is to examine the particular facts of the case, determine whether or not any loss in money or in money's worth has been occasioned to the dependents, and if it determines that it has, it must then use whatever material appears best to fit the facts of the particular case in order to determine the extent of that loss. Now, irrespective of the breadth of that proposition, what we can say is whatever our judge did in this case falls within that. And measured against, therefore, the observations, the judgment of Lord Justice Latham, we say it is simply unsustainable to criticise the judge in this case at first instance for his approach or for any of his conclusions as to how to determine the extent of the loss. I'll come back in a moment to discuss, to deal, if I may, with the why would one go for commercial care, why would one not, why might one go for discounted gratuitous care. But that's the breadth of Court of Appeal authority from as recently as 2001. So not historic cases, but and not an early statement in the development of this area of law. 2001 seems comparatively recent to some of us, but 20 years ago, I suppose. This is not early in the development of a line of authority. This is comparatively recent and is suitably broad to reflect, as my Lady Justice Davies said, the unique difficulty of grappling with personal injury cases in general, but in particular fatal accident cases where each turns on its own facts. So we say that those are the guiding principles, if necessary. And as I say, we don't say that it is. We would suggest that insofar as, for instance, Mr. Justice J endeavoured to lay down particular principles or guidelines in Rupa Singh, they don't take precedence over what Lord Justice Latham said in O'Loughlin. But I don't think I need to go there. I don't need to make that submission to this court, because this court is simply identifying whether our judge, if I may call him that, the trial judge in this case, went wrong. And we say it is abundantly apparent that he didn't. I've skated over very many issues. I'm not sure whether there's anything particular on ground one that I need to deal with beyond that. As I say, my lady and my lords have our skeleton. We've set it out there. We've set out the logical approach that the judge adopted working his way through, and we say, for the reasons I've now, I hope, elaborated on, it is an approach which is beyond reproach. Do
you want to deal with the authority, the late authority that came in, the National Foster Care?
Yes. Yes, of course. Thank you. I don't want to take... if my lady doesn't mind, I won't take you to its text.
You've taken... I mean, you've got the point that, as I understand it, Mr. Kent was making.
I do. My lady, yes. Essentially, the ratio of that decision, as I read it, is that foster workers can form a trade union. It goes no further than that, as I read it. But even if it does, and even if it identifies that being a foster worker or foster carer is an employment relationship, that is not dispositive of the question of whether this dependency arose from the marriage or arose from a business enterprise. Because the mere fact that somebody is an employee is not fatal to there being a dependency. We see, for instance, the case of Mallion and Plummer, where the wife was employed in the husband's business. But there was a benefit that arose. Now, I appreciate we're not comparing identical situations in Mallion and Plummer, and the perhaps sidestep issue of whether a foster carer is to some extent in an employment relationship with a local authority.
As I understood it, that was underlying the point Mr. Kent was making.
But, my lady, even if, perhaps the best way to put this is that I think going back to what my Lord Justice Stuart-Smith said earlier, is that this was a married couple who decided to foster. These weren't two professional dancers who chose to marry. And the judge is, as part of his inquiry into the facts, entitled to assess the reality of the situation. Now, we've used that expression a lot in our skeleton argument, and I won't take you back to it, but it includes looking beyond the face value of payments from the husband to the wife in Mallion and Plummer. It looks beyond the face value. There's a reference in our skeleton also to Head, the recent case my lady will be familiar with.
Lord Justice Bean.
Yes. But the key is not whether one of those parties is employed. The key is the underlying rationale, if I can use that word.
Does it arise out of a relationship?
Does it arise out of the relationship?
Yeah.
And the evidence in this case, we say, even without the judges clothing it in compliments as to the nature of their care and their intention to form a family, it's clear they were married. They did not have children on their own. They made this choice. And lady, we say it's really it is as simple as that. It is as simple as that. It is as simple as that. Is there anything else I can assist the court with in ground one? If not,
No. Thank you.
I'm grateful. Ground two, which is the question of whether the court takes account of the foster allowances. Again, my lady, our submissions on this are admirably brief. They span over pages 19 and 20 of our skeleton arguments, pages 111 to 112 of the core bundle, paragraphs 70 to 76. We say, really, the answer to my learned friend's appeal is threefold. Firstly, and I won't go back to the way that I explored previously through the cases of Jones and Notting Hill investment. So we say this was not an argument which was comprehensively or indeed tangentially raised below. The judge was not invited by Mr. Kent to approach this case when coming to a jury award on the basis that he should decide what the jury award should be and should then deduct the foster allowances.
Then what?
On the basis that he should decide the jury award and then deduct from it whatever might be identified as the fostering payments or fostering allowances. That simply is not how the case was argued below. And my Lady Justice Davies was entirely right in identifying that a judge, but it was the trial judge himself who said, and with the greatest respect, I don't think it was misconstrued as being a point about mitigation or non-mitigation in the technical sense. It was a question of netting off one against the other. The trial judge effectively said, I wasn't addressed like that below. That's not how this case was argued. And that, in isolation, I won't repeat what I said about Jones and Notting Hill, but my lady, even if I'm unsuccessful about that in respect of ground 5, I reiterate those points with greater clarity and emphasis, I hope, for their bearing on this point. If it's not a point raised below, it's not too late to raise it now, because, for example, we would have explored in detail in evidence Mr. Kent's broad brush assertion that it's £50,000 or £60,000 to be taken into account. We never got further than that below because it wasn't a point that was being pressed below. We didn't identify which aspects of any sums payable to Mr. and Mrs. Witham initially and then to Mrs. Witham latterly might have been allowances, which might have possibly constituted pay or remuneration for what they did, which might have been expenses and which might have been support payments for the children. That level of detail wasn't gone into, and that compounds, we say, the Jones and the Notting Hill point that this is, it just doesn't get off the ground. It shouldn't get off the ground before your lordships. We do then identify two alternative ways of dealing with it if it does get off the ground. And for my lady and my lord's notes, there's first of all, at paragraph 73, if and insofar as Mr. Kent suggests that Mrs. Witham's receipt of a greater proportion, that is the whole of any fostering payments after Neil's death, should be set off, we say that is caught by Section 4 of the Fatal Accidents Act as being a benefit accruing as a result of the death.
I mean, the most it could be would be a greater proportion.
Indeed, but again, we don't know a greater proportion of what.
Yeah.
Which is why the point stalls and stops. And the third point, the third aspect of dealing with ground 2, is really simply to step back and consider what it is Mrs. Witham, what it is on behalf of Mrs. Witham we were claiming and identifying as her dependency. Before the accident, this family received something, we know not the detail of what, from the local authority, but Mrs. Witham had the benefit of the time voluntarily given to household tasks and to the children by her husband to release her to go there. After the accident, it may be the case that there are still exactly the same benefits. But that's entirely beside the point, because we're saying her loss is her dependency on him, and that's what's gone when he dies. The fact that there are some benefits received before, if they can be called benefits, allowances, whatever they may be, the fact that they're received afterwards is simply neither here nor there in how we present our case, and is neither here nor there in the calculation of the nature or the extent of her dependency on her husband. Again, I'll pause and commend to the court our submissions in writing, as I say, only over 2 pages, 19 and 20. If there are any questions in relation to our position on ground 2, I'd be delighted to deal with those. If not, we're on to ground 3.
No?
No, I'm very grateful. We're doing all right now. Ground 3 is the issue of how the judge was to value the dependency. And in a sense, that's answered by the passages we've already looked at in O'Loughlin and Cape. I hesitate to say it as broadly as this. The judge can do what he likes. The judge can adopt an appropriate, what he considers to be appropriate, or she considers to be an appropriate measure. In this case, my learned friend has taken you already to Nower. I won't take you back to that, but you will. Actually, no, perhaps I will. If I may be indulged, if we can go back to Nower, which is at tab. So sorry.
20.
20. I'm very grateful. Thank you. And if within an hour I may take the court paragraphs 25 to 27 of the judgment, which are those to which Mr. Kent took you. And Mr. Kent advances the argument that, as we see at paragraph 25, Mr. Poole, counsel for the defendant in that case, argued vigorously there should be no award. And Mr. Justice Bean, who's say no stranger to personal injuries litigation, Mr. Justice Bean is familiar with this territory. has identified what he considers to be the principles. And again, pausing for a moment, nothing Mr. Justice, being as he then was, said in Nower, would be out of kilter with O'Loughlin and Cape, Lord Justice Latham. The court is not mandated to apply a deduction for national insurance for tax.
Well, I wonder whether that's right. I can see that general principle would be that you would get what you would need to pay yourself if you were going to get replacement labour, for example, and continue to do your own job. You'd have to pay the tax and national insurance. But what is unusual here is that the claimant had to do this child caring herself, and therefore she wasn't going to employ anybody, and therefore one can look at her commercial value, as it were. But if one's paying the tax and national insurance, it does seem to me at first blush to be not quite proportioned, to use the language of Section 3, to pay elements which cannot be satisfied, cannot be paid. It's not quite like the other cases, the cases that are cited. You get rid of your Rolls Royce, you can decide whether or not you get another one. Here, there's a certain limitation on what this claimant can do.
The court will forgive me if I say both yes and no. What the court is doing in this case, in a let me start in a different way. A conventional personal injuries case. I'm injured, I break my leg, I'm at home. My wife looks after me. In those circumstances, gratuitously provided care is conventionally assessed, following Housecroft and Burnett, as being identifying a commercial rate, because that person has done it out of compassion and gratuity, saying they would be overcompensated. It's a fair and appropriate sum to deduct. That's to give into the hands, it's paid to the injured person, me in that hypothetical situation for my broken leg, to be held on trust, see Hunt and Severs, House of Lords, for the person who provided the care. And it's to give them an appropriate level of recompense for their care for me. It's a different task the judge is undertaking in this case when he's seeking to value not care which is actually being provided to Mrs. Witham, but he's seeking to put a value on the... He's seeking to value what Mr. Witham would have done. And in that sense, an objective measure would be how much it would cost to have gone out and, the language is inapposite, but to have bought a replacement Mr. Witham. What's clear is from Housecroft and Burnett is that, again, it's not laying down a mandatory rule that in every case, even in gratuitous care, that 25% is to be deducted.
Well, one must be a bit careful about saying that the judge has complete discretion in all these various ways. I mean, the judge couldn't, for example, when looking at loss of earnings, look at gross loss of earnings. That would be an error.
No, that would...
And so there are certain limits to what a judge can do.
There are, of course, certain limits, but even in the context of a personal injuries case, when there's a convention, one calls it a conventional Housecroft and Burnett deduction, it sometimes varies depending on the sort of job the person providing the care might have done. What rates would their tax would they have paid? But equally, in some cases, and indeed, taxing my recollection, and I'll have to see whether perhaps somebody behind me could find whether in the judgment the judge passed any comment as to the nature and the magnitude of the care that Mrs. Witham provided for Mr. Witham when he was still alive, in the year in which he was seriously unwell and seriously deteriorating his health. Because what one sees in a number of personal injuries cases is that if there is care of greater intensity, the judge will sometimes reflect that by either making no deduction in the Housecroft and Burnett way, or by taking off only perhaps a notional 10 or a 15 or a 20%, 25%. There's no hard and fast rule. So a judge is entitled, we say, to reflect, even in a conventional personal injury case, the difficulty or the magnitude or the intensity or the unusual hours, perhaps, of the care that's provided in their discretion in what, if any discount they make from what would be a commercial rate. So the house got rate.
What was it put to the judge that he ought to provide net rather than gross earnings, as it were, notional net?
Forgive me, net rather than gross
Earnings is a
care
wrong.
costs.
I'm sorry. Yeah, cost assessed on a net rather than gross basis.
Forgive me if I turn me back in my my extremely helpful junior has reminded me that although my lady and my lords don't have before you, and nor do I at my fingertips, the two respective care experts' reports in this case, our shared recollection is that the defendant's expert, much as I characterised her earlier as being rather harsh in assessing the number of hours, the age at which children with autistic spectrum difficulties would cease to need adult care or input, she approached the quantification of care in the same way. That is, that she approached it on the basis of saying...
I'm not sure that's very helpful. It's not an expert matter.
It's not an expert matter, but it was how my learned friend then presented his case to the judge. So the judge was presented...
I insist there is a document in the
is there?
bundle. Supplementary bundle, page 95, is further closing submissions on alternative child care calculations. And we're contending for 25% off, based upon the defendant's care expert, who was not preferred.
Thank you. I'm very grateful to my learned friend. That was recorded. Forgive me. The detail that slipped my mind, but that the judge was then being presented because my lord Sir Patrick Elias had asked, was that argument run in front of the judge? And the answer is yes, it was. In a sense,
the judge doesn't refer to it at all.
The judge doesn't refer to it because he takes it as part of his preference for the approach of Ms. Hannon, our care expert, over their care expert. Mr. Kent had adopted Miss Gowan's, I think, figures in his closing submissions, and we had adopted. In fact, if it assists, well, let me just find what we. Increasingly helpfully nudged from behind. May I pause for a moment and reflect on what I've just been told and see if it will assist answer my lord's question.
Yes, 25%.
Forgive me, yes. My lord, if you turn in the core bundle behind tab 5 to the judgment below, on page 52 of the bundle, paragraph 64 of that judgment.
Could Mr. Kent just repeat the page number he gave us a minute ago?
It's page 95. In the supplementary bundle. Yeah, page 95.
95.
My lord, I was taking you to within the judgment at tab 5 of the main bundle in paragraph 64 of the judge's judgment below, where he does indeed accept that he was addressed on whether a discount of 25% should be applied or not.
But sorry to labour this, but is that a 25% reduction because that would be the norm for something which is gratuitously given, or is this tax and national insurance? And it seems to me they're slightly different things.
In a sense, those two are the same, in that the underlying rationale, I think, of Housecroft and Burnett is that if care is given gratuitously, the funds are held on trust and given to the provider of that gratuitous care, but they're not received as pay as such, so they don't have to account for tax and national insurance.
I see, is that the logic of it?
That is,
I didn't realise that. That's an important.
Yeah, that is the logic of it.
Well, that's an important point. I accept. Yes. I see.
So in this sense, what the judge is doing is trying to quantify what it would have cost and the language again is clumsy, so forgive me, but to acquire a replacement Mr. Witham.
Can I, this is my fault, just looking at that passage, which is about 2/3 down, where he finds the commercial rate that says no 25% discount for the reasons set out above. Where's that? Where's the reasoning why 25% isn't correct?
The first 5 lines of 64, isn't it?
Is that right?
Maybe.
Right. Okay. Thank you.
My own friend and I both think it is simply that he makes a positive decision that the commercial rate is.
And that's the end of it.
And that's the end of it.
Right.
Would my lady forgive me if I tell my
No, not at all.
It might assist if we look at Housecroft. If we may, just for one moment. I won't detain the court long with it, but it's at tab 11 of the bundle. And it's, again, this is a print from, I think, from the All England Law Reports, but internally paginated in the top right-hand corner, page 14. Which I think we see three lines down is page 343 of the All England Law Reports, first volume, 1986. And it's the middle paragraph, which my recollection is Mr. Kent took you to previously. And just a little below the middle of the paragraph, there's a sentence starting, so in cases where the relative has given up gainful employment.
Sorry, you have to. I'm sorry, my fault. I was making a note. Could you just tell me?
Yes. Authorities Bundle, tab 11.
Yeah.
Housecroft and Burnett. Internal printed, page 14.
I've got that far.
Middle paragraph should be redlined. Yeah. Pretty much in the middle of the middle paragraph, just a little below the middle of that paragraph, and just off to the right, there's a sentence beginning, so in cases where the relative has given up.
And that's the passage the judge relied on right at the end of 64.
Yes.
Yeah.
So where the relative has given up gainful employment to look after the plaintiff, I would regard it as natural the plaintiff would not wish the relative to be the loser, and the court would award sufficient to entitle the plaintiff to receive that result. The ceiling would be the commercial rate. So again, Housecroft and Burnett doesn't mandate an approach of taking 25%.
But that is on the basis, the notional basis, that the money is going to be held on trust to compensate the giver of gratuitous pay.
That's right, my lord.
Whereas the distinction that the judge draws in paragraph 64 is that is not this case. This case is how much would it have cost to, or how do you value the cost of Mr. Witham's services?
Well, that's precisely it.
And that we get from the middle of the paragraph.
Yes, we do.
Have I understood that correctly?
Yes.
Thank you.
Lord, I think I have covered what we set out in writing in respect to ground 3 between pages 21 and 24 of our skeleton, which again I commend to my lady and my lords to read again if I may. May I? Would you forgive me if I turn my back and see if there's anything more? Unless my lady or my lords have any further questions in respect of... Yes.
Yes, please. And I'm probably being slow. When you were still dealing with round 1, and I asked you whether it would have been wrong to assess by reference to loss of income, you then said it wouldn't have been, it would have been net income. And looking at your schedule, I think it's page 11 or 12 or something, it is done on net income.
I'm sure it would have been, yes.
You stood, and then you say, well, what the judge did was stood back after looking at loss of earnings and thought that was a bit steep. I think that's...
Forgive me, I speculated that he may have done.
Right, because he doesn't actually say that, does he?
No, what he says is he doesn't want to go, he doesn't believe he could go down the loss of earnings route.
Yes. And, of course, just looking at the calculation for a loss of earnings dependency, which I think is page 14 or so, if I can put it this way, you put in some fairly wacky assumptions to get you up to 881,000.
I'm flattered, my lord.
Sorry, it's a technical term.
Oh, Lord, we also included ongoing pension.
Lots of it, yes, because the multiplier, yes, applying the multiplier of 9.41, which is, as it were, like for the period of...
Yes. But
you're at 319,000 as opposed to 661.
Then asserted an ongoing detriment beyond
then
that.
there's an extremely, shall I say, beautifully crafted way of getting it up to 841. But of course, it's come back to the same point about whether the judge looked at it and thought that's a bit steep. We don't know whether he would have given you all or any of that.
No,
and similarly, it's difficult for us to take the alternative calculation as being validation in any way of the loss of services, which is what I thought you were heading for when you made that submission.
No, my lord, what I seek to do is to uphold the judge's approach and calculations. If you're against me on ground 5, I'd like to hold it to the date of May 2020. If there's uncertainty as to what might happen, I still don't have a cogent answer to give you about remitting this case. But on any basis, we seek to uphold the judgment.
And just going back to where we started this morning, on the information that is available to you and you're telling the court on instructions, the question of whether or not the children are going to return, it remains open in the sense that it's not finally decided against her. You said this morning that it's still her hope
It is
to get them back and ultimately to adopt them.
What I cannot do is clothe that hope with any authority or confidence. I'm simply relaying that that's her optimism.
Thank you.
Whether I can assist my lady or my lord's name. Okay. I'm grateful. Thank you. Thank you very much.
Lady, I'm grateful to my own friend for his succinct submissions, leaving me a bit of time to reply, but I will be brief. Can I think this invitation has been accepted, to hand in simply the schedule that was attached to Lynn Hannon's report, which shows the calculations. I wonder if that could be taken. We don't need to go through it.
I don't think there may not be.
There is, yes.
Oh, fine.
Could those go? They show the calculations prepared by Lynn Hannon, which were accepted in every respect. I don't think there was anything that was not. I think there was one aspect. There was a claim in respect of the deceased mother, was there? Mother-in-law, and she was not an eligible dependent.
Thank you so much.
And one can see running down it that, for example, there's a gratuitous care rates given in the first box of £11.15 an hour, and then commercial rates £15.90 an hour, and then various add-ons. And the 6 weeks extra is term time 43 weeks, school holidays 15 weeks. That amounts to 58 weeks a year. So that's 6 weeks extra.
Where's the 6? It's my fault. Where's the 6 weeks extra here?
Well, you just have to work out that if one sees under the bottom box, term time 43 weeks, school holidays 15 weeks. Mm-hmm. So that comes to 58 weeks.
All right.
That's how it seems to be done in these cases, and there are various expenses and so on. So those are the add-ons, and in fact we then get right through to things like fish tank care and dog walking and so on at commercial rates.
forgive me, I'm really out of date. I haven't looked at one of these for schedules for a long time. But why do we get to 58 weeks in a particular year?
Well, because if you're doing a commercial care package, you have to allow for staff sickness and staff holidays. So if you employ two carers, say, you become the employer, and you have to provide. You have to have someone.
But how does that translate into a 58-week year?
Well, because in reality, you are employing someone while he's on holiday or she's on holiday, and you employ someone else to take over the care, or while they're sick. And 6 weeks seems to be a convention.
Okay, so this is assuming that the 6 weeks is paid.
Exactly. So this is exactly what you would have if you've had a very badly injured claimant, for example, who must have professional care. And so you calculate every possible item. But, lady and my lord, my learned friend, in making general points, said that it was these cases are fact specific. Well, of course, in a way, that's our point as well. This is a very unusual set of facts, and that's why we've sought to analyse what it was the judge was seeking to do in identifying a loss of services dependency. He said the judge was simply doing what a jury was doing, and then asking himself, should I award loss of earnings or should I award the commercial care rate? Well, in fact, he didn't do that, because he said loss of earnings was not open to him. So, in fact, he, by his approach, steered himself into that commercial care direction. In addressing the ground one, my learned friend made what we submit is an interesting observation about the way in which the reason why there was a loss of services dependency. He said, although Neil Witham was being paid, it was a gratuitous service being provided, because they were joint foster carers. And by his staying at home, which would have enabled Mrs. Witham to go out to work, he was, as it were, I think he said, he was taking more responsibility than she was, and was taking off her shoulders that element of responsibility she would have had as the foster carer. The problem, and one understands that absolutely as a matter of logic. I see the way my learned friend puts it. The problem with it is that the care award that's been, the award for commercial care that's been made is based on Lynn Hannon's report, which was written on the assumption that the two children were dependents, and is not an attempt to evaluate that element of care that Mr. Witham lifted off the shoulders of Mrs. Witham, or would have done if she'd been able to return to work. The children require care, would have required care at weekends, in the evenings and so on, which both of them would have contributed. He wasn't therefore taking the entire burden. And if that was the approach to be adopted, then that's another reason why this isn't it isn't right simply to say, well, imagine this was a conventional care claim for children who become orphaned. This is what it would cost. And so this is actually a third way of doing it, which is, but I think never advanced at the trial, but one sees the logic of it, but it's lifting off the shoulders of Mrs. Witham some of the burden, enabling her to go out to work. But it's not the claim that has been advanced, and it's not the claim that Miss Hannon has evaluated in that schedule, in that document, or the award that the judge has made.
Did you submit below that the Hannon hours, as I understand them to be, should be salami sliced because Mrs. Witham was in fact providing some of those hours already?
No, because our care expert also proceeded on the basis, on a like-for-like basis with Miss Hannon. She simply looked at it from the point of view of
making the submission.
Of a child. I'm sorry, Miller?
That wouldn't have prevented you making the submission.
No.
But if this is an assessment of all the care that the children need, which I think is what you were submitting a moment ago, my understanding until now has been that although Mr. Witham's looking after the children meant that Mrs. Witham was able to go out and work, there must have been times when she was contributing to this care.
Yes.
But you didn't submit that it should be reduced for that
Well,
reason.
I didn't, but this today is the first time we've heard it being identified in that way. If my learned friend had said so.
Well, I'm sorry to identify it for you, but then it just flows out of your previous submission.
Yes, we had a number of submissions about the nature of how you get to evaluate care. It's very difficult because, of course, these involve subjective judgments as to how much time someone spends on the school run or preparing meals or whatever, that sort of thing. There was quite a debate about that. But the answer to the question is no, we didn't invite a salami slicing approach. But we weren't facing that even as an alternative. We were simply facing a claim that it really is just look at the childcare cost, and that's the way in which you should evaluate the dependency.
Wouldn't salami slicing be appropriate anyhow? Because whether she would still be contributing a proportion of the care, but wouldn't the critical thing be that nonetheless, because of her husband's situation, because he was taking the lion's share, it did relieve her of that obligation and enable her to work. Wasn't that the critical point?
Well, that's the way in which it's just been put by my friend.
Is it very different? I mean, it means that she's relieved of enough of the care to be able to work. And whether that means she's relieved of all of it or some of it.
Yes. Well, my lord, that brings us back to the logic, leave aside the authorities, that she's lost the opportunity to go to work. But my learned friend seeks to uphold a judgment which is seeking to evaluate the service that Mr. Witham was providing to her. And he's just explained that service can be identified as taking some of the burden off her shoulders. Yeah. And so it isn't the same, therefore, as the whole of the childcare provision. He was saying that, understandably, because he had to deal with the point that, of course, Mr. Witham was being paid for this activity. And incidentally, the NUPFC case does determine in terms that the foster carer is in an employment relationship with the local authority. My learned friend relies upon Ogden and Cape, but with great respect, if one looks at what Lord Justice Latham was saying, he wasn't saying, say there must be some loss and then it's a complete free-for-all as to how you assess it. It is conventional in any tort claim that you both identify whether there is a loss and then seek to put a value on what you have identified. You can't say, well, there's a loss and therefore we'll put a value on it on some completely different basis. And that is really our complaint here, that it's been used as a gateway for a full commercial cost childcare award, which doesn't relate to the loss of services dependency that has been identified, but which the judge said is the ability to go out to work, freeing Mrs. Witham up. Ground 3, Mr. Justice Bean clearly is familiar with this area. So is Mr. Justice J, for that matter, and he said in paragraph 49 of the Rupa Singh case, I think whether I took you to it, that the authorities show that sometimes the commercial care is right and sometimes a gratuitous element. And sometimes the commercial care falls to be discounted to reflect the fact it's gratuitous. In other words, it's case specific. And here we have unusually a situation where there can be no doubt there cannot ever be the cost incurred any more than Mrs. The claimant in Limpo Chu would ever incur the cost of extremely high cost of medical care, which was being provided to her through the NHS. These are costs. These effectively are expenses that are never going to be incurred and cannot be incurred. My learned friend suggested that it may be there's a difference between the Fatal Accidents Act approach to loss of dependency and personal injury claims, but Mr. Justice Bean was approaching it on the basis that there wasn't a difference. And he cited Daly, which is a personal injury case. And indeed, it does look from the dicta I've taken the courts to, that there is an attempt whether it's a dependent's loss of services dependency or a claimant's need for care, whatever it may be, that the courts approach it in much the same way, which is a way which is fact-specific and takes account of all the takes account of the reality of the situation, which in this case is that there won't be any commercial caring in place. My lady and my lord, I hope I've sought to respond to my friend's submissions, and unless there are any other matters, those are my submissions in reply.
Thank you very much indeed. Well, you will be unsurprised to hear that we will reserve the judgments in this case. When they are completed, they will be sent to the parties for the amending of any typographical areas, but no further argument in the case. We will then be looking to the parties to agree an order and any issues as to costs, and if they cannot be agreed, then we will accept written submissions as to that. Thank you all, both teams, for the assistance that you've given the court, and we will aim to get this out as soon as possible, but I cannot guarantee that it's going to be this term. Thank you.